So, let's talk about those words you see everywhere. Act, statute, regulation. You've seen them, right? Do they all mean the same thing? Knowing the difference tells you everything. Who made the law, how much power it has, and even how you might challenge it. Getting this distinction is absolutely crucial.
This video was created with AI to support SQE1 study. We are independent and have no affiliation with the SRA, Kaplan, or the SQE. We do not share exam content, and our videos are for informational purposes only and should not be used as legal advice. Please check and refer to primary legal sources and recommended prep guides as you study.
Today we're going to slice right through that confusion. We're going to build that solid foundational knowledge you need to absolutely nail this part of the exam. Okay, so here's our game plan. We'll kick off with the absolute basics, the foundation. Then we'll jump into the two main types of legislation. After that, we're tackling a really tricky one, territorial application. Then we'll put it all into practice with some SQE-style questions. And we'll wrap up with a quick recap of the key takeaways and those common traps to avoid.
Okay, let's get into our first major topic, primary legislation. This is the big one. You know when you see on the news that a new law is being debated in the Houses of Parliament? Yeah, this is what they're talking about.
So what is it exactly? Well, in simple terms, it's law that's made directly by Parliament. You'll hear it called an Act of Parliament or a statute. They mean the same thing. And I love this analogy. If our whole legal system is a house, then Acts of Parliament are the main structural beams holding everything up. They're the blueprint set down by Parliament. The key takeaway for your SQE1? This is the most powerful form of law there is.
So let's take a look at how these things are actually put together. Knowing your way around an act is a fundamental skill, and it's definitely something you'll need for the SQE1.
You could almost think of an actor like a book that has a standard table of contents. For your exams and in real life, you've got to know these key parts. They're like signposts that tell you exactly what the law is, how to find it, and, this is a big one, when it actually starts to apply.
The short title, well, that's the easy one. It's simply the common name you'll see and use everywhere. It's the title you'd see in the news or in textbooks, like the Equality Act 2010. Makes it nice and easy to talk about.
The citation, on the other hand, is its official, unique reference number. When you see something like 2010 C15, it's telling you that the Equality Act was the 15th act to receive royal assent in the year 2010. It's basically the law's unique serial number. And this brings us to a trap. Please remember this. An act is not necessarily law the moment it's passed. You always have to check the commencement section. It tells you the actual start date, which could be months later, or even triggered by a separate government order.
And this right here is the core of the UK Constitution. It's a principle called parliamentary sovereignty. And what does that mean? In a nutshell, it means that the UK Parliament is the boss. It's supreme. This quote says it all. Parliament can legislate on any issue it wants. It can make or unmake any law it chooses. This is a huge, fundamental concept for the SQE1, so make sure you've got a handle on it.
Okay, but what happens when the words in an act aren't 100% clear? Well, that's where the courts step in. And it's called statutory interpretation. The case of R.V. Allen is a perfect, almost funny example. So get this. A guy was charged with bigamy for marrying a second time. His argument was pretty clever. He said because he was already married, the second marriage wasn't legally valid, so he didn't technically marry anyone. The court was like, nice try. They said that would be an absurd result, making the law pointless. So they interpreted the word marry to mean going through the ceremony of marriage. The big takeaway here for your exam is that courts won't just let a clever loophole defeat the whole point of a law.
So we've established that Parliament makes these big, powerful acts. But think about it. They can't possibly write down every single tiny detail for every situation. I mean, the government would just grind to a halt. So what do? They delegate. They pass the power down. And that brings us to our next topic, secondary or delegated legislation.
So what is secondary legislation? It's law made by government ministers, like the Secretary of State for Health. But, and this is the really important part, they can't just make up whatever they want. They can only make these rules using specific powers given to them by a parent Act of Parliament. Let's go back to our house analogy. If the Act is the main structure, the big beams, then secondary legislation is all the detailed stuff. The plumbing regulations, the exact type of wiring, the fire safety standards. It's the nitty-gritty that makes the house actually work.
This table is perfect for your revision notes. It lays it all out. So on the left, you've got primary legislation. Who makes it? Parliament. What's its purpose? To set the big picture, the main framework. And where does its power come from? From parliamentary sovereignty itself. Now, on the right, secondary legislation. Who makes that? Government ministers. Its purpose? To fill in all those technical details. And its power? Crucially, it comes from a parent act. The classic example you need to know is a statutory instrument, or an SI for short.
Okay, let's add another layer to this. We need to talk about Wales. So, the Welsh Parliament, or Senedd Cymru, has been given the power to make its own laws for Wales in certain areas. This is called devolution. Think of it as the UK Parliament in Westminster delegating a big chunk of its lawmaking power. These Welsh laws are called Acts of Senedd Cymru. Now, here's the exam tip. These are considered primary legislation. They're the big deal laws, just like an act of the UK Parliament, but they only apply in Wales and only for those specific subjects they've been given power over, like health or education.
Okay, this next bit is super important, and honestly, it's an area where a lot of people get tripped up. It's all about territorial application. See, it's not enough to know what a law says, you have to know where it actually applies. Getting the difference between extent and application wrong is such a common mistake, so let's focus and make sure that doesn't happen to you.
So, first up, the word extent. The easiest way to think about this is jurisdiction. Which legal system does this new law belong to? For most of the laws we're talking about, the UK Parliament makes law for the jurisdiction of England and Wales. Think of England and Wales as one single legal territory for this purpose, so the extent is England and Wales.
Okay, but then we have application. This is different. This is about where the law has a real, practical effect on the ground. And here is the key point for your exam. A law can extend to the entire jurisdiction of England and Wales, but a part of that law might only apply to Wales, or only apply to England. So the extent can be broad, while the application can be very specific.
This example should make it click. Let's imagine a fictional transport act. The whole act, as a piece of law, extends to England and Wales. It's part of the law for that entire single jurisdiction. But now look at the details. Section 1 sets new speed limits, but only for motorways in England, so its application is just England. Then, Section 2 creates a new transport body, but only for Wales, so its application is just Wales. See? One act, one extent, but two different applications. That's the difference.
Phew! Okay, that was a lot of theory. So, you know what's next? Time to see if it's all sunk in. We're going to try a couple of practice questions. Don't stress if you're not sure. The point is to test yourself and see where the gaps are. All right, have a read of this first one. A government minister issues a statutory instrument. Read through the options, take your time.
And the correct answer is B. Why? Because a statutory instrument is the textbook example of secondary legislation. Its power is delegated. It's borrowed from a parent act of Parliament. This also means C is wrong. Because its power is borrowed, it can be challenged in court if the minister steps outside the lines drawn by that parent act. A is wrong because it's not primary legislation, and D is wrong because it's clearly not an act of the Welsh Senate.
Okay, one more. An act says it extends to England and Wales. Got it. But then one specific part, Section 5, is only about local authorities in Wales. So how would you describe Section 5?
The answer here is B. This is exactly the kind of question they love to ask. The whole act, the entire document, extends to the jurisdiction of England and Wales. But the practical effect, the application of this one little section is just for Wales. Getting that distinction is so important.
Okay, we have covered a ton of ground, so let's pull it all together in a final recap. This is the stuff you'll want to scribble down in your revision notes, key points, and just as importantly, the common traps you need to sidestep.
Remember, primary legislation, that's the supreme law from Parliament. Secondary legislation, that's the detailed rules made by ministers, always leaning on a parent act. Acts of the Senate, they're also primary legislation, but only for devolved stuff in Wales. And the big one? Extent is the whole legal jurisdiction. Application is where it has a practical effect. Now, the pitfalls to avoid: don't forget that secondary legislation can be challenged. And don't make the mistake of thinking acts of the Senate are secondary legislation.
And one final exam tip for you. Do not get extent and application mixed up. Extent is about the legal jurisdiction the law belongs to, like England and Wales, but application is about where that law actually has a practical effect. For example, an act could extend to the whole of the UK, but a specific section might only apply to Wales.
If you can master these key points, you are going to have a rock-solid grasp of this for your SQE1. Thanks so much for joining this new 2 law breakdown, and seriously, good luck with your studies.